Hi, everybody. Excuse me. Hey, Eve. Hi, Rakes. Hi, Annabelle. Hi, Crafty with Amy. What did I do with my pen? I have an absolutely splitting headache right now, but let's try this. Amy, I am doing Audrii Cunningham and Jasmine Moss and we can talk about Scott Peterson, but we're playing this little game that I introduced last time. Can you guys hear me? Nobody's saying anything. How's everybody's day? How's everybody's week so far? Oh, thanks, Rakes. Glad somebody can hear me. Okay, I posted the link, didn't I? Did it post? Yes. Okay, so I don't have too many people in here. Chris, shut up. I'm going to block you. So, is anybody doing anything exciting this week? All I do is go to doctors and therapy. Not very exciting for me. I know, Audrii Cunningham. Should we talk about her first until some people get in here? What a terrible, terrible outcome. Oh, yeah, I should have said hi, Chris, instead of shut up, Chris. All right, whatever. Let's just see. I was gonna Google Jasmine Moss again. We can talk about her. No, you don't have to leave. Blah, blah, blah. Ooh, okay. So this Jasmine Moss, I don't know if you've heard about her, but she owns it's Jazzy Body or something. And she posted some pictures. We need to put you and Chris in a corner. We put Chris in a corner. So this Jasmine Moss, this broke yesterday, and she posted some pictures of her 5-year-old kindergarten-aged daughter in her waxing salon giving bikini waxes to women. She posted a video and she posted some pictures. I have the pictures. She said she worked 10 hours straight doing bikini waxes on these adult women and made $744. She was training her and going to put that money towards her future dreams. Like, seriously? So her Facebook page got taken down with the video, and I thought about posting the pictures. I don't know if YouTube would like them or not. They're not really showing any actual anything disgusting. They're not showing the girl's face or anything. But seriously, a 5-year-old, what is a 5-year-old doing bikini waxes? Yeah, it's pretty disgusting. So anyway, she's been arrested and charged with child neglect and child abuse. She's in Memphis. Now, she operated the business out of her home. Oh, definitely, Amy. There's no doubt. However, she has a girlfriend who's saying that it's okay. People don't understand what was really going on. We saw the pictures. I mean, for one thing, it's illegal, right? You have to be a licensed esthetician. Pretty sure that 10 hours a day violates child labor laws. I can think of 1,000 things that were wrong with that. So I wonder what'll happen with her court case. So anyway, Audrii Cunningham. If you haven't heard, they did find her body this afternoon. Apparently, the main person of interest there, Don McDougal, led the police to the places that he had stopped that day, although he did not admit that he did anything to Audrii. He did go to these places. People saw him with law enforcement under a bridge, by the river, and different places yesterday. So today they lowered the river, the Trinity River, and divers found her body. So they're expecting to charge him with capital murder. Right now they're just investigating. Said her body wasn't visible to the naked eye. I wonder if he weighed it down. I don't know, because she's been gone long enough. She would have been floating. Yeah, it's really sad, and this guy is sick. I feel sorry for Audrii. Her dad's got, I forget if he had a drug or assault charge too. So he isn't exactly awesome. For some reason, the mom doesn't have custody. But this guy lived in a trailer on Joshua Cunningham, which is Audrii's dad. He lived in a trailer behind the house. And he's got a very long criminal record. I looked, drugs, assault. He's got a big swastika on his arm. Okay, he was arrested on an unrelated charge, and I believe that was assault. Could be they were, and he actually was looking for her. Yeah, it did, didn't it? And he was searching, knocking on doors, asking people if they saw her. I mean, that's just typical, predator behavior. Is to involve yourself in the search to try to find out, what the police know and stuff. The sheriff said, it simply tells me he's trying to give the appearance that he has no play or he's not at fault in her disappearance and that he's part of the concerned parties, which I'll agree. Yes, he was previously charged 17 years ago with indecency with a child and pled down to child enticement, which meant he did not have to register as a sex offender because that's not a serious enough charge that you have to be registered. He took this was a girl under 17. He removed a girl. There was two girls in a bed. He removed one of the girls and then climbed in next to the other girl and pulled down her pajama bottoms and her panties. So even if he wasn't registered as a sex offender, I mean, you could tell by looking at the guy, he's been in prison a lot. Yes, hello, Lake Superior girl. I agree, absolutely. Yeah, what were they thinking? Said he's a friend of Joshua, her father's, although he's quite a bit older. And this McDougal, he was advertising in a lot of swingers groups on Facebook. I saw screenshots of his posts looking for a couple. Oh my God, the guy's a nightmare. It said he was seen at a mechanic shop near Highway 59 in Livingston the day Audrii went missing. Workers at the shop told Eyewitness News off camera that McDougal was there trying to get a part for his blue Chevy Suburban, adding that he was filthy, covered in dirt, and acting suspicious. And they found her backpack first. So they used information from him and then phone pings and GPS. Yeah, he's gross. Hi, Bob. How are you? Oh, yeah. Her, Audrii's dad, Joshua, has an assault causing bodily injury charge from 2011. I see that, I know the father hasn't spoken. I don't know. Yeah, the mother spoke out. I don't know because, the father, I read one report that said that they didn't know anything about the father. Yeah, he kind of stayed under the radar, didn't he? Probably feels guilty, and he doesn't want to be a lightning rod for everybody's blame, I'm sure. So this guy has a email, Kitten Panda 79. I thought that was kind of odd for a criminal. I know everybody loves Bob. Okay, so who wants to come up on panel and do this lawyer thing with me? Somebody better. Annabelle? Oh, Annabelle. Where are you, Annabelle? Rakes, do you want to come up, Amy? Open panel. Oh, come on, you guys. Somebody come up here. How are we going to play this if nobody comes up? Oh, you guys. Annabelle, where are you? Well, maybe this isn't going to work out. I thought this would be really interesting. I'm watching. You're watching wrestling. No, Annabelle, I think you misspelled that. You're resisting is what you're doing, not resting. All right. I'm just gonna grab you, baby. It's not a weird thing. I just rather actually be talking to someone. Yeah, Bob won't go up either. All right. Here's case 1. False Graph versus Long Island Railroad. women's wrestling. I know oh, you're not helping. Okay. Brooklyn, New York. Falsecraft is everyone's favorite negligence case. A man ran down the platform with a plain-looking package. He was trying to board a Long Island Railroad train that was just leaving the station. The train guards, ignoring a Long Island Railroad rule to not allow passengers to get on moving trains, helped the man aboard. One pulled him up to the train, the other pushed him up from the platform. The man dropped his package, which contained fireworks, which predictably exploded. The explosion knocked over a scale at the end of the platform, which landed on Helen Falsecraft, injuring her. Hi, Annie B. Falsecraft wanted to reach the deep pockets of the railroad, so she sued the Long Island Railroad for the negligent actions of the guards. Does Falsecraft win? What do you think? Anybody? Annabelle, are you thinking while you're resting? Dropped his package. Oh no, Amy. Is this going to be another funny one? Does Falsecraft win? Here's something to consider. Should people be responsible for every injury caused by their negligence, no matter how unlikely? Are fireworks legal in New York? This was in 1928. These are just some important legal cases, precedent-setting cases. Okay, so far, you guys are wrong. Sorry, Annabelle and Amy. Falsecraft loses. Guards acted reasonably in terms of Falsecraft. It was not foreseeable that she would be injured. Falsecraft tried to establish that the railroad, because of the negligence of the guards, was legally responsible for the chain of events that led directly to her injury. However, in a 3-2 decision, the court said that the unforeseeable explosion broke the chain. We are responsible for injuries we can reasonably foresee. The guards could not expect that the plain package wrapped in newspaper would explode. Benjamin Cardozo, Chief Judge of the New York Court of Appeals, wrote that the actions of the guards, if a wrong in relation to the holder of the package, were not a wrong in relation to Mrs. Falsecraft. Amy, are you sure you don't want to come up on here? Poor representation. One who jostles one's neighbor in a crowd does not invade the rights of others standing at the outer fringe when the unintended contact casts a bomb upon the ground. I think I'm not good at this. What about if Falsecraft sued the person who dropped the explosives? Now, I think that it's not so much poor representation as it is that she didn't sue that guy because he didn't have any money. It said she wanted to go after deep pockets, and I think that's why she lost. I know, Amy. Amy's got me laughing, and we're not even doing John and Jane tonight. Let's see. Okay, there's a judge that said that it was negligent. If the contents were broken, to the owner if it fell upon and crushed a passenger's foot, than to him. If it exploded and injured one in the immediate vicinity, to him also. Hi, Misha. Nobody wants to come up on panel. Would you like to come up on panel with me? We already went over Miss Jasmine Moss training her daughter to look at adult women's genitals up close, and poor little Audrii Cunningham, another little girl suffering for her parents' bad choices. Okay, here's a good one. Send me the link. Are you going to come up? Oh, thank God. Okay, come on up. Come on down. Misha, I'm just on my phone. Just click that link and I'll put you right in. Eve, do you want to turn your camera off, or okay, you got it.
Hello.
Hey, thank you.
I thought come up here for you won't be alone.
I know, I don't want to be all alone. Amy should come up here. She's got us all laughing.
Tell Amy come up here with me.
Yeah, Amy, come on. Okay, case number 2. This is Shropshire County, England. Oh, were there cliff notes for this? We went over it last week. We did some practice cases. I think there was 10. It was really hysterical. Everybody was laughing their ass off. And then I posted the principles of negligence on my community tab. I see you up there being weird. She's calling you weird, Eve. Okay, this is a case. This is a case from 1837, Vaughn versus Menlove. It's called the "Sorry I'm Stupid" defense. Okay, we'll see how this works. In merry old England, a farmer named Menlove built a hayrick at the edge of his land. Whenever you pile a lot of organic matter, like hay, in one place, the center of the pile heats up and sometimes catches fire. There are some things farmers can do to keep this from happening. Menlove put a chimney in the middle of his hayrick, but his neighbor, Vaughn, thought Menlove had not done enough to prevent a fire. For 5 weeks, Vaughn kept warning Menlove that his hayrick was dangerous even with the chimney, but Menlove ignored him and decided to chance it. Then, as Vaughn had predicted, Menlove's hayrick caught fire. The fire spread to Vaughn's land and burned down 2 of Vaughn's thatched cottages. I don't know. We'll see, Misha. Vaughn sued Menlove for negligence. Menlove's lawyer argued that because Menlove did not possess the highest order of intelligence, he was not liable for negligence because he'd done the best he could. Does Vaughn win? What do you think?
I have no idea.
Why are you laughing, Annie? Can you do anything with your property? Can you build a giant bonfire, for example? I would say yes, as long as you control it. Should an inexperienced adult be held to a lower legal standard than a more experienced adult? Yes, I would say that. Was there an IQ test?
Well, if there is, I'll fail it.
But this wasn't really an inexperienced adult because he was a farmer, right? Annie B says he does not win. He does win. Vaughn wins. Menla breached his duty by failing to meet the standard of a reasonable person. This case introduced the idea that everyone is held to the standard of the reasonable person of ordinary prudence. In general, a reasonable person obeys laws, is cautious, listens to warnings, does research, and makes sure that their actions do not hurt people or their property. Judges and juries decide if a person has acted reasonably. The court said that Menla breached his duty to act like a reasonable person who is a farmer. Well, that's what I said. He is a farmer. He should have known. In this case, a reasonable farmer in 19th century. Hi, Betty Smith. Yes, Misha, you got it right. The court said that Menla breached. Okay, in this case, a reasonable farmer in 19th century England would know about the potential for a hayrick fire and would have done the research necessary to learn how to build a safe hayrick. Moreover, they would see that a hayrick fire close to the property line could spread to their neighbor's land. That Menla was not smart does not entitle him to a lower standard. Courts give people a lot of freedom in how they manage their property, but when their carelessness damages neighbors' property, they are responsible for the damage. Okay, Misha got that right. Who else got it right? Okay, we're going to go on to case number 3. This is New York, 1872. And remember, these are all earlier cases that kind of set the standard for other cases. If I'm pleading stupidity. Are you sure you don't want to come up here? Okay. 1872 Cosgrove v. Ogden. Isaac Ogden owned a lumber yard that unloaded lumber from ships and sold it to mills. His company received a large load of lumber that his foreman, Walter Brown, was in charge of stacking. Ogden told Brown not to stack lumber close to the sidewalk, but he did it anyway because it was easier. Uh-oh. I'm not thinking this is headed in a good way. 6-year-old James Cosgrove was on the sidewalk when the stack collapsed. The lumber rolled onto the sidewalk and injured him. Cosgrove's parents sued Ogden for their son's injuries. Ogden said that neither he nor the company was negligent. In fact, he had tried to protect passers-by by telling Brown not to stack the lumber near the sidewalk. He said that Brown's negligence caused the injury because he did not follow instructions. Does Cosgrove win? Okay, what say you? Eve, you don't have to type it. You're on panel.
I know, but I wanted to type it. I want to be funny tonight too.
Yes. No, Misha, I'm sorry. Walter is not at fault. Oh, that's good, Bob. Good news. A lot of children going missing. The little kids' parents win. Yes, they do. Employers are liable for the negligence of their employees at work. You're responsible. The court said that employers are liable for an employee's negligence when the employee is doing the master's business, even if the employee is not following instructions. Cosgrove could have also sued Brown, but Brown probably had little money. The fact that ordinary workers do not normally have money to pay damages was one driving force behind the idea that employers would be liable. Yeah, if you're on the clock and yeah, I'm saying that, yes. Employees that don't listen, but I bet he didn't have a job after that. I'm just guessing. I don't know. Even if it hadn't collapsed, if you were lazy like that and the boss saw it, yeah, I would say go. I would say you're done. Okay, case 4. We're going to do 10 of these. Yeah, there's a lot of. I just read about another guy that was going to take a test and disappeared, but they said they think he voluntarily left. Because it didn't appear that there was any foul play. He was in college, though. Okay, case 4. This is in Niagara Falls, New York. 1921, Wagner versus International Railway Company. Arthur Wagner and his cousin were riding the night train between Buffalo and Niagara Falls. The train was crowded, so they were forced to stand next to an open door that the conductor had forgotten to close. The train lurched at a sharp turn and threw Wagner's cousin into the inky night. The passengers shouted, "Man overboard," and the engineer stopped the train. Wagner immediately jumped out and started searching for his cousin. After walking a little bit, he reached a bridge and found, upon a beam, his cousin's hat, but nothing else. About him there was darkness. He missed his footing and fell. Wagner sued the railroad for the injuries he suffered while trying to rescue his cousin. Does Wagner win?
No.
You don't think so?
I'm just guessing.
I don't know, but the conductor didn't close the door. Okay, should a mother win a suit if she is injured while rescuing her child from a fire caused by someone's carelessness? Yes, I would say yes. Should the law protect people who attempt rescues in dangerous situations? That's a good question. Sunshine, hi. Okay, Wagner sued. What's everybody saying? Yes, Railway is going to be sued. Crafting with Amy, you're wrong. Sorry, girl. Yes. Rescue, Wagner wins. This is Court of Appeals of New York. Rescue is a foreseeable consequence of danger caused by negligence. Is this making sense to everybody as we go through these? The lower court sided with the railroad. It said that the conductor should have closed the door, but Wagner's rescue was his own choice and not the result of the conductor's negligence. In other words, Wagner attempted his rescue on his own and assumed the risk of his injuries, so the railroad was not liable. Yeah, I don't agree with that. Then Wagner took his case to a higher court, the New York Court of Appeals. The Court of Appeals sided with Wagner and overruled the lower court. The judges said that rescue was a foreseeable consequence of danger created by negligence. So Wagner won his case. Judge Benjamin Cardozo wrote, "Danger invites rescue. The wrong that imperils life is a wrong to the imperiled victim. It is also a wrong to his rescuer." This judge was unanimously confirmed to the Supreme Court later. Yes, it does. What is that, Amy? KRS. I can see now. Okay. Let's go.
Crap and Family needs to come up here with me and you.
I know. She does. I don't know. She's a conscientious objector. not willing to answer the call. Okay, I had to take a drink. Case 5, Birmingham, England. This is a relatively new one, 1997. Mullen versus Richards. Teresa Mullen and Heidi Richards were two 15-year-old girls having fun fencing with plastic rulers in their classroom. Uh-oh. It was a game that was commonly played at their school. Then, one of the rulers shattered and a piece flew into Mullen's eye. Tragically, the injury was severe and she lost sight in that eye. Mullen sued Richards for the cost of her injuries. Does Mullen win?
I say she
Well,
would, wouldn't she?
if she sued her parents, but yet Mullen voluntarily participated in that, is it foreseeable that the rulers would shatter?
Well, the plastic, so you kind of can count on them. Maybe something like that happen. I would. I mean,
Yeah,
like Ashley says, I'm weird anyway.
well, no, everybody can has an opinion. I don't know yet either. I'm just going through here. I'm saying they both, let's see, they're 15. It said, would you decide differently if Mullen and Richards were 6 years old? If they were 6, I would say that the teacher should have stepped in because they were in a classroom. Okay. No, no, no. Annie says yes. Everybody else says no. Does Mullen win? Mullen loses. They were acting to the standard of 15-year-old girls, and the accident was not foreseeable.
Okay.
At first, well, I'll explain it. You know, there's no right and wrong. We're just trying to reason through this, applying, how courts think. At the first trial, the lower court judge sided with Mullen and told Richards to pay half the cost of Mullen's injury. The judge thought that the two girls knew the activity was dangerous. Although they may not have foreseen the exact injury, the judge said they should have known that someone might get hurt. However, the
Yeah,
appeals
that's what
court,
I said.
yeah, yes, a judge agreed with you.
Yes, he did.
However, the appeals court disagreed, saying that the girls' actions should be judged to the standard of 15-year-olds. The court also noted that the students had never heard of something like that happening before, and fencing with rulers was common at the school. Fighting with plastic rulers was a reasonable activity for 15-year-old girls. Had the two girls been adults, the court would probably have said that the shattering was foreseeable and that both girls were negligent. Yeah, I agree, Sunshine. I agree.
Sunshine, do you want to come up?
Sunshine, do you want to come up? When I was in high school, I was in band. Well, actually, I was in band since elementary school, but in high school, we were a marching band. I played the oboe, so you can't march with an oboe. So I was a flag girl 1 year, 1 or 2 years, and cymbals. I played cymbals 1 year, and I accidentally hit someone with the cymbal in the lip and cracked the lip. My mom held her breath for, I don't know, however many years you have to sue. 5? Because she was afraid that he was going to sue me for hitting him in the face because he was like an aspiring actor.
Hey, Sunshine, it's easy after you get up here and come up that one time.
Yeah. No, I don't think fencing is big here in the U.S., but wasn't that in England? Wasn't that yeah, it was in England. They do stuff like that over there with swords. Oh, come on. Yes. Not only nuns. I had a science teacher that would do that. If he saw you dozing off, he would slap that ruler on your desk. Hey. Oh, Amy, we have a lot in common. Yep. It's a flag girl. Yep. I was in concert and pep band, marching band. Yep. We do have a lot in common. Yes. Well, that's not YouTube land. If a creator tells its subs to jump off a cliff, I think a lot of them would. If you want my opinion. Okay. I love you, but I'll stay in chat. All right. Well, you could come up under an assumed name. Okay. Casablanca, Morocco. This is 1921. Polimus v. Furness, Withy and Company. World War I was raging in Europe when a ship owned by C.A. Polimus docked in Casablanca Harbor, Morocco. Though the ship was owned by Polimus, it was operated and managed by Furness, Withy and Company, which had chartered the ship. Moroccan stevedores hired by Furness were moving cargo, including cases of benzene and gasoline. Yeah, I'd be careful there. Benzene, like gasoline, is flammable as a liquid and likely to explode as a gas. Unfortunately, some of the cases had leaked during the voyage, and the smell of fumes was strong in the ship's cargo hold. Maritime law. A stevedore knocked a heavy plank into the ship's hold. The falling plank made a spark, which caused the vapor to explode and the ship to catch fire. Oh, my cats are going crazy. Safety tip, don't ever try to use gasoline to light a fire, really. The fire destroyed the ship, so Polimus, who owned the ship, sued Furness, who had chartered the ship, for the cost of the ship. Does Polimus win? Huh. I don't know. I find it hard to...
Maybe no. I don't know.
I find it hard to think that a wooden plank would send off a spark. You have to have metal. Nobody's guessing on this one. Is this one too hard?
Maybe no.
Well, yes. What does Elise? Hi, Melissa Brown. I would think, yes. He chartered the ship, so basically he's renting it. It seems like you'd have to take reasonable precautions to not burn down the ship. You knew you were transporting dangerous goods, right? Yeah, Sunshine, I agree with that. Okay, let's see. Polimus wins. The destruction of the ship by a plank falling into a hold filled with flammable gas was foreseeable. Clearly, the dock workers were negligent, but that would mean that they're working for Withy, the charter. Careful workers would not allow a plank to fall into the ship's hold. If a plank did fall, then reasonable people would expect the cargo and ship to be damaged. Furness, you may think that the liability for damage should have been small because the plank is small and its impact would normally have been minor. But the court thought that just because most of the time the damage is small, it does not mean that you get to escape responsibility if things go horribly wrong. Over time, judges became unhappy with this decision. See, it was in 1921. And this is Morocco. They thought that the ship's destruction was not foreseeable, so when another dock working case went to trial, the Wagon Mound case, in which a welder caused a fire that spread over an oil slick and sank his ship, the court sided with the welder. It said that the chain of events was not foreseeable. Still, the Polimas decision was never overturned. Today, the danger of these fumes is well known and thoroughly regulated. Because an accident like this is now foreseeable if it happened today, Furness would be liable for failing to ventilate the hold or contain the fumes. Yep, I agree with that one. Okay, case 7. Everybody ready? It's called Hog Wild.
Okay.
This is Van Zant County, Texas. 1974. I was going to say that wasn't that long ago, but hell, it's 50 years ago. Does that seem like that long ago to you? Eve?
Well, I'm old, so you might be, you know.
I'm old too.
Oh.
Do you have a pre-class? No. Wait, no. What do you be? I haven't talked about the case yet. Okay. In The Wizard of Oz. Oh, this is 1974 Marshall versus Rain. In The Wizard of Oz, the farmhand Zeke is a nervous wreck after rescuing Dorothy from the pig pen. Pigs have tusks and are not to be messed with. Pigs bite. I can tell you that for a fact. Plus, they weigh a lot. They knock you over. Yeah, I wouldn't mess with a pig. Paul Marshall and John Rain owned farms next door to each other. Marshall, this is a neighbor. This is what's that show about the neighbors? Deadly Neighbors or something. Marshall had 200 pigs and Rain had 2. One of which was known to be vicious. Occasionally, a pig would escape and have to be captured and returned. Well, he only had 2. Rain's mean hog escaped and rampaged on Marshall's property for 10 days. The boar charged Marshall and his wife 12 times. It even held Marshall prisoner in his own outhouse. Okay, Amy, what you got? What you got to say about that? Yeah, despite being yeah, I'm sure. I'm waiting. Despite being an expert marksman and having 2 guns, Marshall did not shoot it because that would have been unneighborly. On day 10, Marshall finally told Rain about the situation. He put a note on Rain's gate that said, "John, your boar has gone bad. He is trying to chase me off the farm. He stalks us just like a cat stalks a mouse every time he catches us out of the house. We are going to have to get him out before he hurts someone." This is in 1974. Sounds like something that happened in 1800s. That afternoon, Marshall was preparing to drive to his house in Dallas. Before walking to his pickup, he checked to make sure the coast was clear. Little did he know that the pig was waiting for him. It charged Marshall from behind, and when he put out his hand to stop it, the pig bit his hand. Yes, they will bite. Marshall sued Rain for his injuries. Does Marshall win? Well, I would say yes.
I'll agree with you.
You do?
Yes.
Yes. Everybody's saying yes. Okay, let me think about this. Rake says yes. Well,
Yeah, crap, Amy, yes or no?
Paul gave him notice, so he sues. Yes or no? Yes or no? One or the other. All right. Did Marshall assume the risk that he would be injured? Well, he knew the pig was out there. He knew the pig was vicious. Did he assume the risk of leaving the house with the pig? He knew it was there because he checked to make sure the coast was clear. Right, it is on his property, Misha. Boy. Oh, it said, would the result have been different if a trespasser had been attacked on Rain's land? No, because a trespasser would not be assuming he would assume any risk, right? Because he's trespassing. Okay. I want a mean pig. Does Marshall win? Okay. Everybody that said yes is correct.
Yay.
Rain was strictly liable for the injury caused by his vicious hog. Initially, a lower court ruled against Marshall. It said that because Marshall did nothing while the pig chased him around the farm for days, he assumed the risk of injury. The Supreme Court of Texas disagreed. It said that Marshall did not, as a matter of law, voluntarily expose himself to the risk of the attack by the hog when he walked to his car on his own property. The court said he had instead only a choice of evils, both of which were wrongfully imposed upon him by Rain. He could remain a prisoner inside his own house, or he could take the risk of reaching his car before the hog attacked him. If he stayed inside, he would have surrendered his legal right to use his own property. The hog was known to be vicious. Rain should have noticed its absence and gone looking for it. Well, that's a good point. Where the hell did he think it was for 10 days, even if he didn't see the note? I mean, you have to feed those things, right? The court said that if you keep a vicious animal in Texas, you're strictly liable for the injuries it causes. An exception to the strict liability rule for vicious animals concerns trespassers. If Marshall had been a trespasser on Rain's property and the hog attacked him there, it's likely that he would not win. It is this exception that shields a junkyard owner from a lawsuit by a robber who was bitten by a junkyard dog. Yeah, I agree with that too. I'd rather someone shot my pig. Yeah. Well, it was nice that he didn't. Exactly, Misha. Yes. Yep. Oh, then sue me. Hey, Leandra. Yeah, that happens. A burglar got hurt. Yeah. We'd have to know the specifics there to judge exactly why that was. But, yeah, burglars are great for trying to sue people if they get injured. Barbecue. Yeah, he could have shot the pig, had a barbecue, and invited Rain over to partake. Okay. Case 8. Preoccupied teacher does not notice danger. This is in Broadstone, England, 2009, Orchard v. Lee. Two 13-year-old boys. Okay, now we know 13-year-olds are only responsible for acting reasonable for 13-year-olds. Two 13-year-old boys were playing tag in the schoolyard. Sebastian Lee was running from his friend when he realized that he was heading toward Michelle Orchard, the school's lunchtime assistant supervisor. She and her colleague were chatting as they walked across the yard. Lee changed course to avoid Orchard, then turned around, running backwards to taunt his friend. He misjudged his direction and ran into Orchard's cheek with the back of his head. Her injury was serious, and she sued Lee for the cost of her medical bills. Does Orchard win?
No.
What?
I'm guessing no. I'm probably wrong, but
Well, what's your reasoning, Eve?
I
I'm
have
gonna
no
make you,
idea.
I'm gonna make you talk here. Well, they're 13. They're on the playground. She's the assistant supervisor. Sounds like she's not doing her job. She's busy slacking. Probably texting.
Probably.
Um, yeah, yes, I would say sue the school, right? Okay. Does Orchard win? No. Exactly right. Amy gave a straight answer.
Thanks, Amy.
Orchard loses. Playing tag in an area designated for play is not negligent. The court said that Lee was playing tag with a 13-year-old's level of care. Yep. We learned that from the girls with the rulers. He was not playing with a reckless disregard for anyone's safety. The collision with Orchard was unfortunate, but not negligent. You could argue that Orchard's inaction and inattention contributed to her injury. As supervisor, Orchard would have noticed the game and been able to stop it, but she didn't. When she walks in that area, she should pay attention to what is happening around her. Otherwise, she assumes some risk of injury. Had the boys been playing tag in an area where running was forbidden and ran into Orchard by surprise, then they would have more likely been negligent. I don't know. 13-year-old. Teacher was watching YouTube. Oh my God. Teacher was probably creating a YouTube video. Okay, case 9. 2 more to go today. This is in Paisley, Scotland, 1932. Donahue v. Stevenson. May Donahue and a friend were enjoying some refreshments at the Well Meadow Cafe. Her friend bought her a Scotsman ice cream float, which is ice cream floating in ginger beer. The ginger beer came in a dark glass bottle, and half of it was poured over the ice cream in a large glass. Oh my God. I'm reading ahead and it's gross. She happily ate some of the float, but when the rest of the ginger beer was poured into the glass, a half-decomposed snail came.
Oh, Lord.
Oh my God. Exactly, Leandra. Okay, realizing that she had certainly drunk pieces of dead snail moments before, Donahue suffered shock and nausea. Later, she got the stomach flu and suffered from vomiting and diarrhea. Donahue sued Stevenson, the maker of the ginger beer, for her injuries. The case was unusual for the court because it was one of the first cases where the person suing had neither bought nor misused the product. Does Donahue win? I like root beer. Root beer shakes, root beer floats. We used to have those all the time when we were a kid. Yeah. Does Donahue win? Yes. Most everybody's right. Yes, Donahue wins. Stevenson's duty extended to anyone who might use his product. This famous case, known as the snail and the ginger beer case, was decided 3-2 by the Court of the House of Lords. Before this case, businesses only had a duty to protect their customers. After this case, businesses had a duty to protect anyone who might be injured by their negligently made products. Lord Atkin based his decision on the golden rule, the rule that you must love your neighbor becomes in law, you must not injure your neighbor. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. For the judges, the fact that the bottle was dark was important. It meant that Donahue had no way of discovering the snail. Reasonable people inspect products before they use them. Don't expect to win a case if you accidentally eat the worm in a bottle of tequila. Fluid
Okay.
anxiety. No, wait, I'll tell you. This reminds me of my grandfather owned a grocery store and he had coconut. So I took a coconut home and I never had coconut milk, I was a kid. So I somehow poked a hole in the eye and drank some of the coconut milk. And I thought, oh man, this is gross. Why do people like this? So then I cracked open the coconut and it was solid mold inside. So I know how this lady feels.
I have never drank coconut milk, and I ain't planning to neither.
Well, I'd crack the coconut first before I drank the milk, I think. Yeah, who would see this coming exactly? However, now they have manufacturing standards for food, the FDA. I don't know if a lot of other countries don't have those cases, don't have those laws for their food, which is kind of scary. Yeah. Well, I don't know if people. Oh, I don't know. That was a gross one. Yeah, a lot of people like. I know coconut milk. I use it for cooking a lot. Okay, here is Hastings, England, 1958. Wells v. Cooper. 1958 is the year I was born. Okay, we are all Frederick Cooper, working to make our own little world better, then finding out we're not perfect. Cooper liked to fix things around his house, so he installed a new door handle on his back door. His work looked professional, and the door handle worked perfectly for more than 4 months. But he had secured the handle with 3/4-inch screws, which were a 1/4 inch too short for the job. Albert, what?
I think am I still fair? I think I just got knocked off.
No, you're still there.
Okay.
Okay, Albert Wells, a fishmonger who made home deliveries, had just dropped off some fish, and Cooper invited him to stay for a cup of tea. As Wells was leaving through the back door, no relation to Don Wells, maybe it is, I don't know. The wind was making the door difficult to close, so he yanked on the door handle. The door handle came off the door, and Wells fell off the back stoop and was injured. Wells sued Cooper for his injuries, which he said were caused by Cooper's negligent installation of the door handle. Does Wells win? To what standard should homeowners be held when making their own repairs? Professional, reasonably skilled amateur, or the skill of your average fraternity brother? I had a girlfriend whose husband went to install a hanging hook on the outside the bathroom door, and he drilled right through the door. He had to keep him away from power tools. Or any tools, really. Oh, hi, Victoria. This is Eve, my mod, the lovely Eve. Okay, everyone is related, including me. I've been called his cousin, Don Wells' cousin. Okay, so does Wells win? Wells got hurt, fell backwards because the door handle came off. How did he know that? How did he know that Cooper used screws that weren't quite long enough? This was in 1958. How would you know that? Okay. What do you think? Nobody's guessing. Are they? Oh, Crafting with Amy. Does Wells win? Crafting with Amy said yes. Misha said no. Cooper has a big mouth. Cooper goes, damn, sorry about that. Okay. Wells loses. Cooper met his duty to perform repairs at the level of a reasonably skilled amateur. What did it say? Oh, he liked to fix things around his house. The court had to decide how skilled you have to be to make repairs around your own house. The court said that you don't have to be a professional, but you can't be incompetent either. Your work has to be at the level of a reasonably skilled amateur. The court said that Cooper's repair met the standard, it looked good, and worked properly in most circumstances. Well, that's a good point, right? This guy was yanking on it. Reasonably skilled. That's a good point. Yes. The court said that the choice of screw length was not an obvious blunder, but a mistake that a reasonably skilled amateur could make. Therefore, it was not foreseeable the handle would detach from the door. The court did point out that there are some home repairs, such as certain types of electrical work, where the duty is higher than that of a reasonably skilled amateur. In those cases, any mistake makes the home too dangerous. I did an electrical project and wired up some lights to make a light box for photography. And yeah, when I went to plug them in, I went in the bathroom where there's a little breaker in the plug. So I didn't blow up the whole house. But surprisingly, they all work perfectly. Are you still there, Eve? Uh-oh, Eve went silent. How hard do you have to pull on your door to fall down? Well, if you were pulling really hard on the knob and it came off, yeah, I could see where he would fall backwards. I've done that trying to pull a package out of the truck. They tell us never use the bands. Never use the bands. Never use the bands. Here I am out in the back on the step, pulling on the band to get this 150-pound box out of my truck. And of course, the band broke. And I went flying backwards. Actually, at one point, my feet were higher than my head. Yeah, don't use the bands. Not even a reasonably skilled amateur, Amy? Don't bring morons into your home. Oh. Yeah, heck, the guy got some free tea. I wonder who he bought his fish from after the fish guy sued him. I'm terrified to mess with electricity. You know, my dad can do anything, so I had some advice from him. And I also went to Home Depot, and asked the electrical guy there in the store if I could put a certain switch that I wanted to put on to turn it on and off to connect them all. And he said, well, you could if you knew what you were doing. I never have gone back to Home Depot. I thought, you fat effer. Isn't their motto, you can do it, we can help? I mean, does he insult all the women customers? Maybe I should have sued him. If he Jane's husband. Jane and John broke up, remember? Well, yeah, I didn't act like I didn't know what I was doing. I didn't ask him how to wire it up. I'd already done all that. I just wanted to install a switch. And I didn't know if the kind of switch that I was holding would work for what I wanted to do. Yeah, he was no help. Jerk. Okay, so that's all I got for tonight. Thanks everybody for joining me. Eve, thank you for being on panel. I don't know where you went. I'm up here all alone again. Anyway, join us next Monday. We'll do 10 more cases and a little, yes. Well, I thought it was reasonable too. I wasn't asking him how to wire it up, but even if I was, shouldn't you have been helpful in that case? Oh, thanks, Annie. You too. Thanks, Sunshine. I'm just gonna keep these Monday nights short. You know, it's been an hour, so just going through having fun. Well, thank you, Amy, for the laughs. Good night, Rakes. Good night, Misha. Good night, everybody. Thanks for coming. And we'll talk to you later. Bye.